Welcome to the Debrief, everybody. New York prosecutors have issued an 11-page memorandum to counsel a judge on how to sentence convicted rapist Harvey Weinstein.
The letter, written to Judge James Burke, says accusers Mimi Halle and Jessica Mann will both make statements at Weinstein's sentencing. But it goes further, noting that prosecutors wish to make a public example of the disgraced former movie producer. Noting the law, prosecutor Jonah Luzzi wrote, "A sentencing court is not limited to the evidence at trial. The need for deterrence of this defendant specifically and of others generally is of particular importance here. It is therefore totally appropriate in this case to communicate to a wider audience that sexual assault, even if perpetrated upon an acquaintance or in a professional setting, is a serious offense worthy of a lengthy prison sentence." Luzzi provided the court a list of 36 incidents of Weinstein's so-called lifetime of abuse dating back to 1978, asking the judge to consider them as well as the assaults on so-called other bad acts witnesses Tara Leigh Wolfe, Dawn Dunning, and Lauren Young. The letter does not ask for a specific penalty, but the judge can sentence Weinstein to up to 29 years in prison. Weinstein's team says the prosecutor's letter was no surprise. They expected the prosecutor to try to allege everything possible during sentencing.
And Weinstein's publicist tells us that the former movie producer fell and hit his head over the weekend at New York's Rikers Island jail. Authorities moved Weinstein to that facility and away from the hospital where he had been staying after complaints of heart trouble. Weinstein did indeed have a stent placed while he was in the hospital. Publicist Judah Engelmeyer says Weinstein is in pain, but he's managing. Weinstein's lawyers are meeting with him today, and they expect sentencing to continue as scheduled on Wednesday morning. 4 guests are with us tonight here on the Debrief. Let's begin with attorney Michael Bryant and former prosecutor Julie Rendelman here in studio. So, Julie, no term of years recommended by Jonah Luzzi in the sentencing memorandum. Is that odd?
It is odd. Most times, especially in New York, when we do sentencing letters, we ask for a specific amount of time. And obviously, we know that the maximum they could have asked for is 29 years. And so the question is, are they going to ask for specific time when the sentencing happens? Are they going to rely on the victims to make their statement as to what they want the sentencing to be? Or are they going to allow the judge to make his own determination based on what their specific sentencing request is without giving any specifics as to the exact time?
Michael Bryant, making a public example of Harvey Weinstein, that seemed to be the overall tone here. So if you're making a public example of someone, it sounds like you're going close to the maximum.
That's what you'd like, of course, and I think Julie's right in not picking a number. It's almost like saying, hey, we don't want to short ourselves unless we ask for the max, which might sound a little bit punitive. Then maybe the judge will give them 20. If we don't want to say 15, we'll let the judge deal with it. But making an example is key to this decision.
And quickly, Julie, 2 primary accusers expected to make statements this Wednesday. Do we expect anyone else to possibly make a statement at a sentencing hearing in New York?
We don't, and the reason is because it would have to be included in that letter in New York in order for an individual to be able to speak.
Good insight from Michael and Julie. Let's turn to our other guests watching tonight. Forensic death examiner Joseph Scott Morgan, who's now a professor at Jacksonville State University in Alabama, and an author, of course, and former federal prosecutor Colleen Middleton. So, Colleen, if you were recommending a term of years here, where would you be on this term here? Would you be close to 29 years, which is the max on 2 counts back to back?
I would, despite the acquittal on the predatory sexual assault. I think that enough testimony came out from the 4 additional accusers, in addition to Halle and Mann, to support a really harsh sentence. I think that the prosecutor, when you're talking about making a public example of somebody, that can backfire. But relevant conduct does come in sentencing. So, I think that I would ask for something pretty strong.
The sentencing memorandum lays out the law pretty well in New York, and it's worded in such a way that anyone can follow along with. Joseph Scott Morgan, I want to ask you about this head injury here. Harvey Weinstein, he's got heart trouble. He has a stent placed. Now he's falling down in prison. He bumped his head, but they're saying sentencing continues. What else can befall this guy?
I don't know. Apparently everything. He's a jinx. Hey, listen, he is now a convicted a sexual criminal, sex criminal. And I don't want them to do anything that would not normally have been done for anyone else in this particular case, because I don't want this screwed up in the sentencing process. From an investigative perspective, they put in a lot of time a lot of sweat and tears into this. Don't treat him any differently. Treat him just like you would everybody else, and let's get this thing done.
No special treatment for Harvey Weinstein in the world of Joseph Scott Morgan. Let's move on to our next case now. The prosecutor who is after real estate heir Robert Durst resumed his opening statement, which now has entered its third day in California. Durst accused of killing his friend Susan Berman in December 2000 because prosecutors think Durst feared she was going to run to police with information that Durst had previously killed his wife Kathleen way back in 1982. Kathy Durst is presumed dead, but her body has never been found. Prosecutors are also tying in the death of 71-year-old Morris Black. Durst was tried for murdering Black, where he took the stand and said a self-defense struggle for a gun ended in a shot to Black's head. The jury in that case acquitted Durst of murder. Durst later admitted he dismembered Black's corpse. Prosecutors say the defendant gave inconsistent statements about when he found out about his best friend's death, Susan Berman's death. There's a 2-day gap between Durst's statements under oath and when a separate friend testified that she told him.
On January 7, 2001, Durst called Kim Langford, who was a mutual friend of both he and Susan. Kim explained to him, told him about the murder, and he sounded shocked. He also related to her during the conversation that he was scared about the reinvestigation into his wife, Kathy. Now, during his testimony in Galveston, Durst again told that same story of having learned of Susan's murder through the voicemail messages on January 9th. He went so far as to explain how he had confronted Susan's son, Sarah, for not having told him earlier about Susan's murder. Now, Durst continued to monitor the media for reports about the case. But remember, he is living at this point in time in Galveston as a mute woman. He has moved there in November. Susan's murder has happened the end of December, and he's back in Galveston.
The defendant's Galveston neighbor, Morris Black, apparently found out Durst was indeed a wealthy heir and was pressuring Durst that perhaps they should live together.
Mr. Durst, the evidence will show, it's not a secret that he's leaving. So he is about to leave. He's moving out. And Morris Black wants him to get a house. That's going to be the circumstances right before Morris Black is going to be murdered.
The jury found him innocent.
No, they found him not guilty.
Okay.
Did not find him
So
innocent.
there's not much difference.
Oh, it's different.
Oh,
No.
But now, there he goes again, Judge.
This is a speaking objection. I don't allow them. So,
What about counsel addressing me?
no, counsel, you should not, Mr. Lewin, and nor should you address Mr. Lewin.
I didn't.
All right. So, Mr. Durst was acquitted of murder in that case. He's no longer in jeopardy in that case. The facts of that case may be relevant in this trial.
You can scrape the tension off the walls with a knife there. Okay, Durst admitted both on the stand in Texas and to movie producers that he chopped up Morris Black's body. Prosecutor Lewin in this case is now trying to say maybe Durst wasn't talking solely about Morris Black's body.
Well, I decided I'd wait till night and then I'd pick it up and carry it out of there. And then I realized I wasn't picking up that body and carrying it anywhere because it was much. I mean, I wasn't strong enough to do that. I could drag it out, but I just couldn't see. I mean, I thought about putting it in a sleeping bag or something and then dragging the whole thing out, but good God, that's ridiculous.
So you decided instead?
I decided to. It wasn't until the next day when I can't just drag it out. I'm going to have to dismember this body.
Well, the evidence is going to show, circumstantially, that when he said, "I'm not taking that body anywhere," that was a reference to Kathy Durst and how he had gotten rid of that body.
That's
The
Judge. That's clearly an argument in conclusion and speculation.
Circumstantial, was it? I'm sorry, Your Honor?
I'll sustain it. Move on.
Prosecutors say the evidence of Morris Black's death is inconsistent with an accidental killing in self-defense. And they say Durst was disturbingly casual when he described dismembering his neighbor's body.
He denied that it took any special experience. The way that he describes it, though, as you listen to him, he's very technical as you listen to what he has to say.
I've been told that a surgeon would cut up a body the same way you would chicken. You go into the joint and you cut around the joint to get rid of all the ligaments, and then the thing comes out. You're not going to go and try to cut through the goddamn bone like I did, which was hard.
Well, you did a pretty good job. The thing that
cutting through a bone is not easy with anything.
All right, let's turn back to our guest one more time here. Michael Bryant, these objections, it seems like these two sides are very unhappy with one another very early on in this case.
It seems so childish. He's touching me. He's touching me. No, he's not. He's not touching.
So
Judge,
it's like a backseat ride in a car.
Oh, it's
on
just
the way
so
to the car.
childish. It's crazy. No, it is inappropriate, and I think it's partly frustration because who's seen an opening like this?
I don't think anyone has. I don't remember ever seeing one that lasts this long. Julie Rendelman, though, as to the core facts, does the state have a good case here?
So my problem is I feel like they have a stronger case in regards to Kathy and had a stronger case in regards to Morris Black. I'm not so sure they have the strongest case in regards to Susan Berman. So I think in a way they're trying to piggyback Susan Berman's case by proving the other two.
Well, okay, and then we wind up with double jeopardy issues, which is why we heard that one objection. Colleen Middleton, I want to jump in with our panel from afar here. Colleen, do you think that some of these objections went a little bit too far? And back to my primary question here, does the state have a good case here? We've got the cadaver note, remember?
Exactly. And there is no evidence of forced entry. We know that, there were payments made to Susan, in a very large amounts. And we have testimony, you could see that Beverly is misspelled here, and it's misspelled again on correspondence with the victim. So, there is good evidence here. Unfortunately, there's no murder weapon, there's no DNA, etc. So there are some issues with the case.
Joseph Scott Morgan, this discussion about cutting up the body, it's shocking, but is it evidence here that this guy actually did it to someone other than the person he admitted to doing it to?
I think the shocking thing here is not so much, and he's absolutely right from a technical standpoint. It's not an easy thing to accomplish, but the kind of disconnect that he has, he doesn't work in the field of forensics. He doesn't work in a morgue. He's not used to this sort of thing, but he kind of disconnects, what we would normally think of the human side of this from the technical side of it. And he begins to talk about this in very flat, plain terms about how do you accomplish this task. So I think that that's kind of an interesting point when you're painting this picture of this fellow that's been involved in all of these horrendous events. Is he a jinx or is this reality?
Many questions, and the jury is going to eventually start hearing evidence in the case once opening statements wrap up. Again, they are in their third day. Still ahead tonight, both sides have rested in the trial of an Iowa mother charged with strangling her daughter to death. That case is straight ahead. Closing arguments expected tomorrow in the case of an Iowa mother accused of strangling her 5-year-old daughter to death with a pair of pajamas. Prosecutors say the defendant confessed. The defense says the confession was coerced. Firefighters found Chloe Thomas dead in her bedroom on July 19, 2018. Her mother, Kelsey Thomas, told detectives she put Chloe down for a nap around 1:30 and then settled down for a nap herself. When Kelsey woke up, she said she found Chloe dead in the closet and called 911. The defense started its side of the case today and rested today. They started by calling the victim's preschool teacher to testify that the defendant appeared to be a reasonable and responsible parent.
I know a few times when she was gone, she would call to tell me that, she had an appointment or was sick, that she wouldn't be there. I can't remember anything specific, but I don't remember Chloe not having things, so that if I sent a note home saying we needed this for class or we were going to be doing something or whatever, Chloe always had what she needed.
Were there any red flags or anything that struck out at all to you?
No.
Did you notice or suspect any type of abuse with Chloe?
No, I did not.
What was your reaction to hearing the news that Chloe had passed?
I was very surprised.
Was Chloe able to tie her shoes?
Yes.
Did you have many 4-year-olds who were able to tie their shoes?
I think to this day she might be the only one.
Did her shoes stay tied when she tied them?
I think so, because I don't remember tying them after that.
Would other kids come to her to have their shoes tied as well?
Yeah, because I used to joke with her. I said, now that you've learned, you can tie all the shoes in the room.
The defense hired a forensic pathologist who testified he believes the defendant's ultimate confession was not consistent with the state's forensic pathologist's autopsy report.
Dr. Cavalier looked at the autopsy report and imagined a strangulation. I looked at the autopsy report and I just simply looked at what was said by Ms. Thomas initially and by the people who were basically taking care of the child. And I found it to be consistent with what they said, a hanging. The major difference here between Dr. Cavalier and myself is that she's imagining a strangulation. I'm not imagining anything. I'm just simply taking what was seen and heard by eyewitnesses and pointing out that what was seen and heard by eyewitnesses is consistent with the autopsy findings. She has no way of measuring the probability that her imagining a strangulation would be correct. Her statement of probability is what you would call a subjective feeling. It would be maybe something that she would vote on if she were in Las Vegas and she were trying to figure out which team was going to win the Super Bowl. Something that she might feel in her gut, perhaps. But in terms of anything objective and scientific that she can use to measure it, there isn't any such thing. Her statement of probability is simply her intuition.
That defense forensic pathologist went on to further explain his own conclusions.
Finding hemorrhage in the neck and in the soft tissues is a frequent finding at autopsy. It can be found even in situations where there's a natural death and the head and neck are basically have engorged blood vessels. Basically having a child that's found hanging and then manipulated in a resuscitative effort. Having a finding of these kinds of hemorrhages that she's described would not be unexpected. However, what is interesting here is that the kinds of hemorrhages that are usually noted in strangulation cases are absent in this case. In fact, usually with a hanging death, there typically are no broken bones or cartilages in the neck because usually a person is quite gentle on their neck when they're hanging themselves. In this sort of a situation, there are no broken bones in the neck. There are no fractures. These are basically described in the literature for strangulation. There are none of these findings here in this particular case.
Dr. Young previously worked in Kansas City, Missouri for 11 years as the chief death investigator for Jackson County. On cross, the prosecution asked him about why he left that office.
Isn't it correct that you resigned in 2006 as a result of 6 prosecutors noting complaints that they could not rely on your opinions?
Not correct. What you underlined in that case, which is a document that I think maybe an appellate court in Tennessee wrote, is a misstatement of fact.
You're claiming that this never came up in transcripts, that they relied on to make a decision.
They did not state what was true. That's not what happened.
So this appellate court essentially is wrong?
Yes.
Our guests are with us one final time here, Colleen Middleton, along with Joseph Scott Morgan. So, Joseph, let's take a look at that case that was just referenced on cross-examination. It says, in part, Dr. Young admitted he resigned as a result of a letter signed by 6 prosecutors from separate jurisdictions complaining they could not rely on his opinions. That is the exact quote from the case. And, Joseph, he says it is wrong. So what's the deal with this guy?
I worked with Tom Young for many years in Atlanta. He was a deputy medical examiner there, and I always found him to be quite thorough and very professional, as a matter of fact. So I don't know what might have transpired relative to his work as a practitioner in another jurisdiction. I know that he was a solid performer when I worked with him in Atlanta.
So apparently the appellate court's got it wrong if we're to believe the testimony that he issued in this case. Colleen Middleton, I'll ask you about this. No broken bone, usually the result of someone hanging themselves, and I have the Epstein bell ringing in the back of my head. Forgive me. So what is it here? I mean, do we trust the defense expert? Do we trust the state expert?
It's going to come down to the jury. I mean, the defense expert, I have to say, was pretty persuasive. It just seems like if you say it's in the literature, it seemed very practical to me, and it seemed very common sense and believable. He's very credible. If it's true that, the state's expert, came up with, imagined the strangulation, etc., and they started with that premise, then anything that follows, of course, can't be trusted. So, I found him to be very credible. I think it's unusual that prosecutors would write such a letter. I don't know if they just didn't like his opinions or they questioned them. But I find that highly unusual.
Maybe a little bit more to dig into there, but the bottom line is the jury has heard its testimony in this case. So here, Michael Bryant, do kids hang themselves?
The whole thing is so
seems a little bit bizarre.
It sounds very strange. And one of the things that made sense to me was the fact that if somebody is strangling you, there might be a thrashing and defensive wounds, and there's no evidence of that on the defendant. If you hang yourself accidentally or on purpose, that's unlikely. That's less likely.
Julie Rendelman, what do you think?
I think it becomes a battle of the experts. We saw this in the last case, and sometimes when there's a battle of the experts, they cancel each other out, and often if they cancel each other out, the jury finds for the defense.
Well, okay, but we also have the confession here, Michael Bryant, and that's the big, what do you call it?
As I've said,
that's the big thing they need to overcome here.
You can torture me for years and hours. If I did not kill my kid, I'm not going to say I killed my kid. I don't care what you do to me or how long you do it.
Julie disagrees.
Because you don't have, every personality is different, and other people are influenced differently by law enforcement.
She didn't seem that soft to me. That's all I'm saying. I don't think she's given in.
And the jury, this is a window into jury deliberations right here on the Debrief. That's likely what will happen. We'll be watching that case and our others tomorrow. And of course, we'll be back here at 5 o'clock for our recap of the day in court. We'll see you then.